how to adopt your counter affidavit and the written address. Before I delve into that, let me explain to you what a counter affidavit and a written address is. A counter affidavit is your own application as a respondent that you will be using in opposing to the application of the applicant. For example, in a criminal case and the defense counsel filed a motion for bail, the prosecution would need to file a counter affidavit, that is a disposition of facts with the written address, that is the argument that the prosecution will use in opposing to the application of the defense counsel in granting the accused person bail. Also, let me use a civil case. For example, let's say in the fundamental right case or a case of dissolution of marriage, application for injunction, the respondent on the other part can file a counter affidavit, that is making the court to see reason why the court should not grant that application. As the phrase implies, counter, that is you want to counter something. So you want to counter an application, that is the court should not grant that application. So the counter affidavit will be disposition of facts why you want the court to reason with you not to grant that application. So that is the counter affidavit. And your written address will be disposition of arguments to support, like principle of laws, judicial authorities, statutory authorities, in support of your facts for the courts to discountenance the application of the other party. So in this situation, you will be the respondent. So let's dive into it. Before I proceed, please subscribe to this YouTube channel, like this video, try to watch the sponsor ad and share this video. So let's dive into it. So for example, you are in the court already and you are the respondent. Okay, you are the respondent, in terms of the application. So for example, let's say I'm the petitioner / respondent, which means I prepared an application. Let's say a case of divorce, I prepared an application and the respondent has raised a preliminary objection to my application. So now I am filing a counter, so which means I am the petitioner / respondent, and the respondent in the substantive suit, the divorce, the respondent now has filed a PO, preliminary objection. So the respondent will be the respondent applicant, while I will be the petitioner respondent. I hope that is clear enough. Okay, so let's dive into it. Since I'm the petitioner, I am already before the court, I will announce my appearance first. So it all depends. The substantive suit, what part are you representing? Are you for the prosecution or the accused person? Are you the claimant or the defendant? So that is how you know when to announce your appearance. So I am the petitioner, I'll be announcing my appearance first. I have a video already on my YouTube channel on how to announce your appearance before the court. So I will try and put the link in the description box, or you try and search for it, how to announce your appearance. You get the video, a very short clip on how to announce your appearance. Okay, so let's dive to the other part. So after announcing your appearance, I am the petitioner, so I will sit. I will allow the respondent applicant to announce appearance. So after that, either me or the other person would notify the court of what the business of the day is. So since it's for application, so since I'm the petitioner, I can just inform the court, my lord, the matter is slated for the motion of the respondent or for hearing of the application before the honorable court. Subject to the convenience of the court, we are ready to proceed. So the court will ask the other party, or probably ask me, have you filed your counter? Are you opposing? I will inform the court, yes, my lord, we are opposing to the application and we have duly filed our counter affidavit. Same has been served on the respondent. The court will confirm from the respondent if the respondent has been served. If it's in affirmative, no, service is very, very important. The court can proceed to hear you of an application that the other party has not been served. Be an infringement on its right of fair hearing. So after an appearance has been done and court is aware of what the business of the day is, so the person who filed the motion will move the motion first. I also have a video on my YouTube channel on how to move a motion, for bail, and also how to move a motion. It's quite similar. I have those videos on my YouTube channel. So once the applicant is done adopting or moving the motion for the motion, so next you would need to adopt your counter affidavit, and this is how you're going to go about it. So the first thing you will do is to inform the court of the date of the counter affidavit. My lord, our counter affidavit is dated the 4th day of May 2024 and filed on same day. you need to note that the court will be writing, so you take it slowly. My lord, our counter affidavit is deposed to by Mary Odedele, although a lawyer should not depose on affidavit, but I'm just using any name right now. Mary Odedele. Our counter affidavit consists of 11 paragraphs. My lord, we are relying on all the averments in our counter affidavit, particularly paragraph 5 and 6. That part is not so necessary because the court will go through all the paragraphs of the affidavit. However, if there are some things you want to really call the court's attention to, you can just mention the paragraphs. That is, you are relying on all the averments of the affidavit, that is everything you have in your counter affidavit, particularly paragraph 5 and 6. My lord, in support of our counter affidavit is a three exhibits. So that is if you have, exhibits are just like documents that you must have referred to in your counter affidavit to support what the opposition you're doing in court, the opposition, the affirmation and the argument you're raising. Okay, so my lord, we have attached 3 exhibits to our counter affidavit. Similarly, my lord, we filed a written address. Don't forget I said written address is your argument. The facts consist of facts, most especially judicial authorities, statutory authorities, to support your fact. That is, you're not just saying this is the principle of the law. Do you understand? So after that, you make the court understand that, my lord, we also filed our written address. My lord, rely on all the arguments therein, and we adopt same as our argument in support of this application. The next line you need to mention as well is that, my lord, we urge the court to discountenance the application of the applicant. Okay, that is the essence of your counter, to discountenance the application of the applicant, and that is all. However, if you want to adumbrate, for example, I have a matter coming up soon, and I am the respondent, so I have filed my counter affidavit and my written address, and I have the intention of adumbrating. I already have a video on my YouTube channel on how to adumbrate, and I explained in that video that adumbration is just you bringing out germane points to persuade the court. The courts, they have a large amount of, like a large workload, even though they will definitely go through every process. But if you bring it to the mind of the court, like, my lord, this is why you have brought this application, I mean, some germane principle of law, if there is a Supreme Court authority, in just 1 minute or two, you may just seek the permission of the court that, my lord, if the court may permit us, just within a minute or two, to adumbrate quickly. Oftentimes the court are like, since you have everything in your process, there is no need for adumbration. But if you may do that humbly and persuade the court, so that the court can grant you that audience and you adumbrate. However, adumbration is not compulsory, except of course when the court requests for such, and probably in the case of final written address. Final written address is just the process you file when both parties, not both parties compulsorily, called witnesses, and you want the court to see facts, issues, and things like that before the court will give judgment. So at final written address, court often demand for adumbration. Okay, but in applications like this, they are not so important, so you may just choose the liberty to do so. And however, you can prepare ahead in case the court asks you, like, oh, what is this application all about? Refresh my memory. You won't just be surprised, or maybe anxiety will not set in. You can as well prepare. Adumbration shouldn't take too much of your time, just to say why the application, what the applicant has filed, and what you have filed. The applicant has filed a preliminary objection, and you on the basis of so and so, and on the other hand, this is your own argument in opposing to it, and that is that basically. Please do well to like and share this video.